You know what my father used to say?
You want me to grab one out of the air? What he used to say?
He used to say to me, don't pee on my leg and tell me it's raining.
This is Ryan at xcannabis.com. This is a report about Scott Shupe, the second one. I'm really happy that his charges were reversed from a case in 2009. I just wanted to mention, this is why I was so venomously against SB 5073. Apparently, Scott Shupe's lawyer doesn't realize that SB 5073 changed Washington Code 69.51A.010, where Section 404 of SB 5073 changed that to where you cannot serve one patient at any given time. What it says now is that once a patient stops being served by you, you have to wait 15 days to serve another patient. Let me just play you what happened with Scott Shupe, and then I'm going to go back in history a little bit here to explain what the deal is.
Operated Spokane's first medical marijuana dispensary. KXY4's Annie Bishop is live in the newsroom with what this means for dispensaries and patients. Annie?
Marijuana debate in our state. The court says the dispensary can sell to several people one at a time, not just one person, period, as law enforcement officials have interpreted, and it also clears Scott Shupe's name. Shupe, who opened the first medical marijuana dispensary in Spokane, was convicted last year of charges stemming from a police raid. But the appeals judges say police lacked probable cause to justify those searches. Within a week of his March 2011 conviction, federal authorities sent letters to all other dispensaries in the region warning them to shut down. Most did, but others continued and wound up being indicted. Shupe's attorney, Frank Civitovich, says his client was very emotional today when he learned of the decision. The ruling also could mean big things for thousands of patients in need of medical marijuana.
Hopefully now we can legitimately talk about how we can open a dispensary without the police worried about it. They're the ones that have been paranoid, which is kind of a flip of that it's being done illegally. All we want to do is be able to have patients have good quality medicine if they're legitimate and they need it. And hopefully this gets us in that direction.
And even with this ruling, Civitonich warns former dispensary owners to be cautious about reopening. Medical marijuana is still illegal under federal law. It's unclear how the feds will react to this latest decision. Reporting live, Annie Bishop, KXLY4 HD News.
It's a Broadway and it's coming to...
Sorry about that. So anyway, that's the reason why I try to warn people. I don't like to be the bearer of bad news. But if you look at what happened in SB 5073, these protections that were applied to Scott Shupe of serving one patient at any given time, being able to serve multiple patients at any given time, well, that changed in SB 5073 under Section 404, where, as before, you can see what the law used to say in RCW 69.51A.010, that provider is a designated provider to only one patient at any one time. Now 69.51A.010 has been changed to read, a person may stop serving as a designated provider to a given qualifying patient at any time. However, that person may not begin serving as a designated provider to a different qualifying patient until 15 days have elapsed from the date of the last qualifying patient designated him or her to serve as a provider. So that just kills that law. And Section 301 was no joke either. That killed the exclusive protections that doctors had. So that's why I warn people, like with Initiative 502. I've warned, hey, it's still a Schedule 1. It's not actually legalized if it's a Schedule 1, and that's under state law. I'm not talking about federal law, I'm talking about state law. SB 57, I-502 gives the 5 nanogram DUID per se limits and all these other things, but you really don't get much out of it. You're not going to get dispensaries. If cannabis is a Schedule 1 drug, it's still illegal on a state level. How can they make the state responsible for qualifying and issuing licenses to businesses that are operating illegally on a state level? They can't be selling a Schedule 1 drug legally, can they? I-502 could have changed that and didn't. I think that's a major flaw in it. But what people gave up for I-502 in regards to what they got in return, the DUID limits and the per se and the taxation and the awful precedents, no home grows. I have to warn people of these things. Hey, maybe you're going to vote in a way that isn't pleasing to the law that I'd like to see, but at least you're educated. Even if you don't take my advice, at least you're educated. But you can see this post right here. I'll post a link to it in the bottom here in the description. But that right there is the link, and you can read about Section 404 of SB 5073 and how the law changed after that. Providers are not safe. You got to know this. Under state law or federal law, cannabis is still a Schedule 1 drug. And that law that protected Scott Shupe no longer exists. Anybody going forward after SB 5073 passed will not get the same protections that Scott Shupe got.
It would mean patients with the card would not be, quote, arrested, searched, prosecuted, or subject to other criminal sanctions or civil consequences under state law, or have real or personal property searched, seized, or forfeited pursuant to state law, end quote. Now, it also requires cops to verify whether someone's on the registry as a patient, provider, collective, or dispensary before performing a warrantless arrest, search, or seizure, or before seeking a warrant. And they can only proceed if they have evidence that the patient is out of compliance or committing another crime. So cops have to actually look up the registry before they can come after you. And even if they find you're a patient, they have to have some other reason to be harassing you. This bill would permit, but not require, it would allow them to courts to allow medical cannabis for use for people on probation or parole. That's groundbreaking. We don't have that in, I don't think, any of the other medical marijuana states where a court, if it wants to, under the decision of a judge, could allow someone on probation or parole to use medical marijuana. This bill would create dispensaries that don't charge state sales tax. California doesn't have that. Montana, we just did the story about them wanting to have a 10% sales tax on dispensaries up there. Washington, no sales tax on dispensaries. It would allow people with prior cannabis convictions to run a dispensary. Yeah, if you've been busted for growing in the past in places like Oregon and Colorado and other medical marijuana states, you can't get involved in the medical marijuana program in that capacity. You'd be allowed to in the state of Washington. It creates protections for patients seeking organ transplants. We call this the Tim Guerin Clause.
That is awesome.
Yeah, Washington State would explicitly protect you in an organ transplant situation if you're a medical patient.
If this passes, I'm moving over the border.
Yeah, no kidding.
If this passes, I'm moving over the border.
Yeah, no kidding.
If this passes, I'm moving over the border.
Yeah, no kidding. And only Arizona has that right now. That's the only medical marijuana state that has that because it's one of the newest laws. It would create protections for patients' right to work. Now, there is a loophole if it's a job that gets federal resources or has some federal requirements, they can get out of it. But generally speaking, a medical marijuana denied employment because of a P-test or be fired or disciplined because of a P-test. Again, only Arizona has that kind of protection right now. It would create protection for patients' child custody. That's right. If you're getting in a divorce and you got a spouse that wants to bring up that you're a medical marijuana patient, that could not affect your child custody. That couldn't be used against you. Again, only Arizona has that right now. It would create protections for a patient's right to housing. Same idea as the work, right? If there's a federal thing, they can get out of it. But otherwise, in the state of Washington, you couldn't be denied housing or kicked out of housing because of your medical marijuana use. It would define cannabis products for the first time. These Washington bills, SB 5073 and HB 1100, would define cannabis products and make it so the weight of the products doesn't count against your possession limits. Right? You know, in some states with medical marijuana, if you make pot brownies, they weigh the entire pan of brownies to determine what the weight that you're possessing is. Brownie and all, not just the cannabis. That wouldn't be the case in Washington. Now, I think maybe Colorado has that, but I have to be sure here. These bills redefine plant so that multiple stalks on one root ball is still just one plant. Now, I don't grow marijuana. Does that happen a lot? You grow and you get multiple stalks coming out of one root kind of thing?
Not really. Probably should turn my mic on. Not really, but yeah. It can happen.
And when it does happen, people get busted for having too many plants. So
right.
That would be cool. All right. It removes the requirement that the conditions in the medical marijuana law, quote, be unrelieved by standard treatments or medications. That's in the law right now in Washington. Like if you have chronic pain, you have to have tried the other standard treatments and medications first before you can get your medical marijuana card. That goes away. It creates collectives of up to 25 patients that can produce up to 99 plants and have 6 pounds of cannabis on the premises. 25 patient collectives, 99 plants, 6 pounds. It allows patients to change providers at any time. That language isn't actually in the law right yet. Now the patients could have that freedom to change providers.
Currently have.
And it retains an affirmative defense if a patient is caught over the limits. If you're caught with over 24 ounces and 15 plants, or if you're a patient / provider, you're doing both, you get double, you get 48 ounces and 30 plants. If they catch you with more than that, you still have the affirmative defense to say, yeah, I needed more than that for my medical condition. And it only needs to be proved by a preponderance of the evidence, which is a legal standard much easier to clear than beyond a reasonable doubt. It's basically if 51% of the evidence says that it was likely to be medical, then it's medical. It provides a pseudo-reciprocity for patients from out of state. Now, it's not that your Oregon, Michigan, New Jersey, Arizona card is going to protect you from arrest, but it will still give you affirmative defense. So patients from out of state caught with medicine could still at least take it to court and say, yes, this was medical, and they'd be protected so long as they were under the Washington limits. It creates a review board to research the effectiveness of the medical marijuana law. It creates a scientific research program into the effectiveness of medicinal cannabis use. It makes Washington state supreme over its towns and municipalities, which means that they can only adopt ordinances that are consistent with these new laws. And what that really means is that the pot-hitting towns, the small towns, the places in eastern Washington, wherever you might be talking about, can't ban dispensaries and collectives, unlike California. In fact, these bills even strike the word marijuana all throughout the law and replace it everywhere with the word cannabis. And it even has an explicit paragraph. What I've always been saying, you need a "this doesn't change existing medical marijuana laws" paragraph written in boldface letters. Remember me saying that? Here's their paragraph. Nothing in this chapter or in the rules adopted to implement it preclude a qualifying patient or designated provider from engaging in the private, unlicensed, non-commercial production, possession, transportation, delivery, or administration of cannabis for medicinal use as authorized under the law. It's a dream come true for Washington patients and for cannabis businesses. You can open dispensaries. You don't have to pay sales tax. You can have collectives of up to 25 patients with 99 plants.
So congratulations, ex-cannabis Ryan. You were right about 5073. That's your big victory, right? You're a prophet, aren't you? You're a prophet, ex-cannabis.
Either you're playing dumb or it's not an act.
You get to hear. They got you by the balls. They spend billions of dollars every year lobbying to get what they want. Well, we know what they want. They want more for themselves and less for everybody else. But I'll tell you what they don't want. They don't want a population of citizens capable of critical thinking. They don't want well-informed, well-educated people capable of critical thinking. They're not interested in that. That doesn't help them. That's against their interest. That's right. You know something? They don't want that. You know what they want? They want obedient workers. Obedient workers. People who are just smart enough to run the machines and do the paperwork. It's a big club. And you ain't in it. You and I are not in the big club. And by the way, it's the same big club they use to beat you over the head with all day long when they tell you what to believe. All day long, beating you over the head in their media, telling you what to believe, what to think, and what to buy. The table is tilted, folks. The game is rigged. And nobody seems to notice. Nobody seems to care.
The voice of the people is the voice of Almighty. But we have said judgment still, loot and fire. Me see it crystal clear. Them sell the people in a deep despair.